crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. After the historic verdict of the U.S. session on July 13, the U.S. Securities and Exchange Commission, SEC, has replied to the ruling by Judge Torres, the long-awaited summary ruling in Ripple v. SEC had just been issued. The presiding judge, Annalisa Torres, came to the conclusion that XRP did not qualify as a security under specific conditions. The SEC's reaction to Ripple's shared victory. The U.S. SEC went home with a victory, albeit a partial one. Following criticism and mockery from the XRP community, the Commission has made clear its position in light of the court's ruling. The SEC may be examining the matter further in light of the comments published by Fox Business. Paraphrasing some of the reply, nonetheless, the agency concedes that it won since the judge ruled that Ripple offered and sold the tokens as investment contracts in violation of the securities laws in certain circumstances. The court ruled that Ripple's sale of XRP to financial institutions was a violation of securities regulations. They were given permission by Judge Torres to sell the asset to the public. Notably, the court agreed with the Commission that the Howey test applies to the securities investigation of Bitcoin transactions. As shown by the summary ruling, the court also disagreed with Ripple's definition of an investment contract. However, the court's judgment made it obvious that the SEC does not have limitless authority over crypto, which may account for the fervor in the crypto market. In response to Ripple attorney John Deaton's request that exchanges list or relist XRP to indicate support for the verdict, the Kraken and Coinbase markets have already done so. This shows the industry's alignment, with crypto leaders like Binance's CEO congratulating the Ripple camp on the victory. The case that the Commission had against Coinbase, which had sold 13 tokens classified as securities via the exchange rather than on launchpads like ECOS and IOs, is rendered completely moot. CoinDesk contributor Preston Bren, meanwhile, believes that the judgment from July 13 merely guarantees continuing uncertainty for crypto issuers, and that only Congress can rectify the situation. However, now that they have been vindicated that Gensler no longer has exclusive jurisdiction over them, altcoins have flashed green following the news of the ruling, suggesting a buying frenzy that saw XRP naysayers miss out on 70z gains while holders of Solana, Sol, Polygon, Matic, and Cardano, ADA, raked in around 20 profit. In its statement, the SEC discussed Ripple's partial victory and how the court had rejected the defendant's proposed test. The judgment will be reviewed by the agency, which might lead to a trial down. Following Judge Sarah Netburn's decision about an SEC UV Ripple lawsuit settlement, numerous members of the XRP community have speculated that the parties would soon reach an agreement. To put things in perspective, Judge Netburn instructed the parties Wednesday to agree on 3 mutually agreeable dates for a settlement conference if they feel it would be beneficial at this time. Eleanor Terrett, a Fox Business correspondent, released the paper on Twitter yesterday. Due to the court's hectic schedule, the judge wants the parties to arrange the settlement conference at least 6 to 8 weeks in advance. According to the ruling, the court will not accept any last-minute requests for settlement discussions. It went on to say that the parties should not anticipate a postponement of litigation deadlines as a result of late requests for settlement discussions. Meanwhile, the ruling caused consternation among some XRP aficionados, with many expecting the dispute to be resolved quickly. Terrett, interestingly, resorted to Twitter to explain Judge Netburn's settlement ruling. Judge Netburn's ruling, according to Terrett, does not imply that a settlement will be reached within the next 6 to 8 weeks. She clarified that the decision simply requires the parties to organize a settlement conference 6 to 8 weeks before the preferred date owing to the court's hectic schedule. The notable journalist who has been following the SEC UV Ripple litigation requested that additional attorneys, such as John Deaton and Jeremy Hogan, emphasize what would happen if any of the parties failed to attend the settlement meeting or reach an agreement. To avoid upsetting the court, pro-XRP lawyer Fred Rispoli said that the SEC and Ripple will convene a settlement meeting. However, attorney Rispoli believes the settlement session, like the last 2, will be in vain. He went on to say that settlements normally happen when the parties involved achieve a reasonable arrangement. It is worth mentioning that if things go as attorney Rispoli predicted, one or both parties would likely appeal Judge Annalisa Torres's summary judgment ruling. According to attorney Bill Morgan, both sides will appeal Judge Torres' decision. Remember that the much-anticipated summary decision was given by the court, which many perceive as a split triumph. While she determined that Ripple's XR programmatic sales do not constitute securities, she determined that the company's XR sales to institutional investors do. Notably, the SEC said in a statement that it is currently evaluating Judge Torres' judgment in order to determine its next course of action. Yesterday, SEC Chair Gary Gensler expressed a similar opinion. According to Gensler, the SEC is upset with the court's decision in the Ripple dispute regarding individual investors. He went on to say that the commission is looking at that section of the decision. Judge Annalisa Torres assigned the U.S. SEC Ripple litigation to Magistrate Judge Sarah Netburn for general pretrial and potential settlement in the latest court filing in the Southern District of New York. Judge Netburn directed Ripple and the U.S. Securities and Exchange Commission to agree on 3 mutually agreeable dates for a settlement conference if they believe it would be productive at this time. Furthermore, since the court has a full calendar, settlement conferences must be planned at least 6-8 weeks in advance. Meanwhile, Ripple CEO Brad Garlinghouse warned that the U.S. Securities and Exchange Commission would face a lengthy process in appealing the court's judgment. He claims that the court itself referred to institutional sales as the smallest item in the XRP complaint. According to others, the U.S. SEC should settle with both Ripple and Coinbase since pursuing the litigation further would have severe ramifications based on precedents in the XRP dispute. A resolution on concerns such as institutional sales is possible. The long-running litigation between the United States Securities and Exchange Commission, SEC, and Ripple was partially resolved, sending cryptocurrency markets into a frenzy. However, many investors seem to be overlooking the second part of the CQZ Ripple issue, which might be expensive for Ripple. Former SEC employee John Reed Stark shared his opinion on the SEC's EVs. Ripple litigation development in a LinkedIn article. Stark comments right up that Ripple's victory, however partial, resides on shaky grounds. But he admits that this is a setback for not just the SEC, but also its chairman, Gary Gensler. The CQV's Ripple judgment is divided into 3 sections. Institutional sales. These are sales made to sophisticated investors and people under a signed contract. The second type of programmatic sales comprises the selling of XRP exchanges, and the court concludes that XRP is not a security. Other sales include XRP sales to insiders, ordinary investors via exchanges, and founders. The XRP coin is not a security in this circumstance. The former SEC official observes that the Ripple decision is troublesome on multiple fronts as a result of this classification. He continues, establish a class of quasi-securities that discriminates and morphs based on the sophistication of the investor who is buying the securities. According to Stark, this is counterintuitive, inconsistent with SEC case law, and unprecedented in this context. On the subject of XRP transforming into security or not dependent on investor intelligence, John Reed Stark observes that this argument seems contrary to sacrosanct and basic investor protection principles. Finally, Stark points out that the judgment indicates that only rich investors are protected by the SEC, while less knowledgeable and ordinary investors are not. In other words, affluent people receive help and recourse, but impoverished people get caveat emptor. This seems unreasonable and undermines the fundamental premise of US securities rules. While there is a genuine risk that the judgment favoring Ripple and XRP supporters will be reversed, it will take some time for it to go through right channels and reach a result. Meanwhile, this decision might be the catalyst for a major bull run.